The flash of red and blue lights in your rearview mirror triggers a universal, primal jolt of anxiety. Your heart rate spikes, your palms may sweat, and your mind can momentarily blank. In that stressful moment, the balance of power feels overwhelmingly one-sided. The officer is a trained professional, acting with the full authority of the state, while you are alone, surprised, and vulnerable. It is precisely in this high-pressure scenario that knowing the boundaries of that authority, the clear, inviolable lines that even law enforcement cannot cross, transforms from legal trivia into essential personal empowerment. This knowledge is your psychological armor and your practical guide. It is not about fostering disrespect for law enforcement, who perform a vital and often dangerous public service, but about understanding the constitutional framework that protects every individual from overreach. The traffic stop is a common theater where your fundamental rights under the Fourth, Fifth, and Sixth Amendments are actively engaged. To navigate it successfully, you must move beyond myth and rumor and ground yourself in the sober realities of statute and precedent. Here, we detail 13 specific actions that police cannot legally force you to do during a routine traffic stop, explaining not just the what, but the critical why and how, equipping you to assert your rights calmly, confidently, and correctly. 1. They cannot force you to answer incriminating questions beyond basic identification. The interaction begins with an officer approaching your window. The immediate, instinctive human response is to explain, to justify, to talk. Resist that instinct. You are only legally obligated to provide your driver's license, vehicle registration, and proof of insurance upon request. The Fifth Amendment's protection against self-incrimination is fully in effect during a traffic stop. The officer's common opener, "Do you know why I pulled you over?" is not a casual inquiry. It is a strategic question designed to elicit a confession. Any admission, "I was speeding a little, I rolled through that stop sign, my taillight is out, isn't it?" instantly establishes probable cause and eliminates any defense you might have had. You cannot be forced to provide this information. A polite, neutral response such as, "I'm not sure, officer," or "I'd prefer not to answer questions, thank you," is a lawful and complete exercise of your right. Remember, anything you say becomes evidence. The Supreme Court has consistently held that the right to remain silent is a core privilege, and while you must identify yourself, you're under no compulsion to narrate your actions or admit to a violation. 2. They cannot force you to consent to a search of your vehicle. This is one of the most critical and misunderstood rights. The Fourth Amendment protects you from unreasonable searches and seizures. For an officer to search your car without your consent, they must have either a probable cause to believe it contains evidence of a crime, or B, a valid search warrant. Lacking these, they will often ask, "You don't mind if I take a look inside your car, do you?" This is a request for you to voluntarily waive your Fourth Amendment rights. The tone may be casual, but the legal consequence is profound. You have the absolute right to decline. You cannot be punished for refusing consent. A clear, unambiguous statement is best. "Officer, I do not consent to any searches of my vehicle." Say it calmly and repeat it if necessary. Your refusal cannot, by itself, establish probable cause for a search. However, be aware that if the officer develops probable cause independently, e.g., claims to smell marijuana, sees contraband plain view, they may proceed without your consent. But never give away this right voluntarily. The power to say no is a fundamental check on state authority. 3. They cannot force you to exit the vehicle without justification, but the bar is low. The rule here is nuanced. In Pennsylvania versus Mims, 1977, and Maryland versus Wilson, 1997, the Supreme Court established that an officer may, as a matter of course for officer safety, order the driver and any passengers out of a lawfully stopped vehicle. This is an order, not a request. You must comply. However, the key precondition is that the initial traffic stop itself must be lawful and ongoing. An officer cannot force you out of your car if they have no valid reason for the stop in the first place. Furthermore, once the purpose of the traffic stop is concluded, e.g., the warning or ticket has been issued, the officer generally cannot detain you further or order you about without additional reasonable suspicion of other criminal activity. So, while the authority to order you out is broad, it is not infinite and is tethered to the lawful duration and scope of the stop itself. 4. They cannot force you to unlock your personal electronic devices, phone, tablet, laptop. This is a frontier of modern constitutional law. The contents of your smartphone are qualitatively different from the glove compartment. Courts have increasingly recognized that a digital device holds the privacies of life and is protected under the Fourth Amendment. Police cannot force you to provide a passcode, fingerprint, or facial scan to unlock your device without a warrant. A passcode is generally considered testimonial. It requires you to divulge knowledge from your own mind and is protected by the Fifth Amendment. Biometric unlocks exist in a grayer area, but many jurisdictions require warrants for their compelled use as well. During a routine traffic stop, absent exigent circumstances, there is virtually no scenario where an officer can lawfully compel you to unlock your phone. If asked, you can and should state, "I do not consent to a search of my phone." Demands for social media passwords or email access are similarly unlawful without a specific warrant. 5. They cannot force you to perform field sobriety tests, FSTs. This is a vital distinction. Field sobriety tests, the walk and turn, one-leg stand, horizontal gaze nystagmus test, are voluntary. You have no legal obligation to perform them. They are investigative tools designed to gather evidence against you, often on subjective criteria that can be failed due to nerves, medical conditions, or simple clumsiness. The officer's request is just that, a request. Politely declining is within your rights. I choose not to perform field sobriety tests, officer. Be aware, however, that refusal may lead to your arrest if the officer has other indicia of impairment, smell of alcohol, slurred speech, etc. Furthermore, this refusal is distinct from a chemical test, breath, blood, urine. Implied consent laws, which you agree to by having a driver's license, mandate compliance with chemical testing after an arrest for DUI. Refusing a chemical test post-arrest typically carries automatic administrative penalties like license suspension. But the pre-arrest, roadside FSTs, they are entirely optional, and refusing them deprives the prosecution of a key pillar of evidence. 6. They cannot force you to wait for a K-9 unit without reasonable suspicion. The drug dog scenario is a common point of contention. An officer cannot prolong a routine traffic stop beyond the time reasonably required to complete its mission, e.g., writing a ticket, to wait for a drug-sniffing dog, unless they have independent, reasonable suspicion of drug-related activity. This was solidified in Rodriguez v. United States, 2015. If the officer has finished processing your warning or citation, handed you your documents, and said, "Have a nice day," the stop is over, and you are free to leave. They cannot then detain you further while waiting for a K-9 to conduct a free air sniff around your car without that additional reasonable suspicion. If you are told to wait for a dog, you may ask a clarifying question. "Officer, am I free to leave?" If the answer is no, and no ticket or warning is being processed, you are being detained, and you have the right to know the basis for that continued detention. 7. They cannot force you to allow a search of your person beyond a pat-down for weapons, Terry frisk. An officer may perform a quick pat-down of your outer clothing only if they have a reasonable, articulable suspicion that you are armed and dangerous. This is a limited search for weapons, not a general evidence-gathering expedition. They cannot reach into your pockets during such a frisk unless they feel an object that they immediately identify through touch as a weapon or contraband, the plain field doctrine. They absolutely cannot force you to empty your pockets as a routine matter during a traffic stop. Any such demand, absent the specific suspicion required for a Terry frisk, is an unlawful search. You have the right to state, "I do not consent to a search of my person." 8. They cannot force you to sign a traffic ticket as an admission of guilt. When an officer issues you a citation, they will typically ask you to sign it. This signature is not a plea of guilty. It is merely an acknowledgement of receipt, a promise to appear in court or handle the matter as required by law. Refusing to sign can, in many jurisdictions, be grounds for arrest, as it is seen as refusing to acknowledge the legal process. However, you have the absolute right to write "copy received" or "not guilty" next to your signature if you wish to make clear that the signature is for receipt only. The officer cannot force you to sign a statement admitting guilt or to sign the ticket in a way that constitutes a confession. 9. They cannot force you to surrender your right to record the interaction. You have a well-established First Amendment right to record police officers performing their duties in public spaces, provided you do not physically interfere with their work. This includes recording a traffic stop from inside your own vehicle. You cannot be forced to stop recording or to delete footage. The officer may order you to stay in the car or move to a certain location for safety, but they cannot lawfully seize your phone or camera simply because it is recording. Clearly stating, "Officer, I am recording this interaction for my own safety and records," is often advisable, as it can promote accountability on both sides. 10. They cannot force you to reveal your immigration status without cause in many jurisdictions. The landscape here varies by state and local law. During a routine traffic stop for a minor violation, federal immigration enforcement is generally outside the scope of the stop's mission. Unless the officer has a reasonable suspicion that an immigration violation is connected to the traffic stop, they cannot prolong the detention to investigate it. In many sanctuary jurisdictions, local law enforcement is explicitly prohibited from inquiring about immigration status during routine stops. You are generally required to provide your driver's license, but if you are a passenger, your obligation to even identify yourself can depend on state law. You cannot be forced to answer questions about your country of origin or citizenship without a lawful basis tied to the reason for the stop. 11. They cannot force you to allow a search of closed containers within the vehicle without a warrant or probable cause. This extends from principle number 2. If you do not consent to a vehicle search and the officer lacks probable cause, they cannot force open locked glove compartments, trunks, or sealed containers like bags, boxes, or pill bottles found within the car. The Supreme Court has affirmed that individuals possess a reasonable expectation of privacy in such closed containers. Even if the vehicle itself is lawfully searched under an exception, like an inventory search prior to impound, the contents of locked or opaque containers within may still be protected unless the police have specific probable cause related to them. 12. They cannot force you to perform a breathalyzer test before an arrest, preliminary alcohol screening (PAS). Similar to FSTs, the handheld preliminary alcohol screening (PAS) test offered at the roadside is generally voluntary in most states, unless you're under 21 or on DUI probation. It is an investigative tool. The evidential breath test, or blood test, at the police station after an arrest is mandated by implied consent laws. Knowing the difference is crucial. You can legally refuse the roadside PAS device without automatic license suspension in many jurisdictions. The refusal may contribute to the officer's decision to arrest. 13. They cannot force you to remain silent about your rights or deny your request for an attorney during custodial interrogation. Once the traffic stop escalates to the point where you are arrested and taken into custody, the dynamic changes fundamentally. You are now under custodial interrogation. At this juncture, the officer must inform you of your Miranda rights, the right to remain silent and the right to an attorney. They cannot force you to waive these rights. The most powerful sentences you can utter are, "I am invoking my right to remain silent," and "I want to speak to a lawyer." Upon hearing these, all questioning must cease until an attorney is present. An officer cannot continue to badger you, imply that cooperation will help you, or force you to talk. Your invocation is an absolute shield, the ultimate question of judgment. Here lies the central, suspense-driven dilemma every citizen must grapple with. Given that you know you can legally refuse a vehicle search, what single piece of observable evidence, a sight, a sound, or a smell, do you believe gives an officer the strongest probable cause to search your car anyway, completely overriding your refusal? This is the critical line where knowledge of the law meets the reality of the roadside. What do you think? Answer in the comments below. Understanding these 13 principles is not an academic exercise. It is the practical application of your constitutional inheritance. It allows you to interact with law enforcement from a position of informed dignity, protecting yourself while respecting the difficult job officers perform. This knowledge reduces fear, clarifies interactions, and upholds the balance of power essential to a free society. It empowers you to be a citizen, not just a subject. If you found this deep dive into your rights valuable, subscribe to the channel for more clear-eyed, legally sound guidance. Turn knowledge into your greatest form of protection.